open this hearing of the Senate Economics Legislation Committee into the provisions of the Treasury Laws Amendment Mergers and Acquisitions Reform Bill of 2024. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present, and extend that respect to Aboriginal and Torres Strait Islander peoples who are joining us today. The committee will be conducting today's hearing via video conference and in person. We are joined by Senator Dean Smith and Senator Nick McKim. I think that is the senators who are joining us thus far today. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind committee members and witnesses who are appearing via video conference and who are not speaking to please mute your microphones. And I note that if questions on notice are taken today, responses are due by Thursday, the 7th of November. I now welcome representatives from the Business Council of Australia and the Council of Small Business Organisations Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today? And we'll start with the BCA.
Good morning, Senator Stephen Walters, Chief Economist of the Business Council.
Good morning, Alice Bailey, Senior Economist of the Business Council.
Good morning, and Cosboa.
Hello, this is Adele Sutton, Head of Policy and Advocacy at the Council of Small Business Organisations Australia.
Great, welcome. Does the BCA have a brief opening statement, and if so, please go ahead.
Thank you, Senator. We do. So thank you for the invitation for us to appear before you today to discuss the Treasury Laws Amendments Mergers and Acquisitions Bill 2024. Corporate mergers play a critical role in the Australian economy, enabling businesses to achieve economies of scale that improve innovation and productivity, lifting economic dynamism that drives economic growth. This benefits both consumers and businesses and enhances the nation's competitiveness, which has slipped over the last 2 decades. The broader context here is that Australia's average productivity growth last decade was the worst in 6 decades. The Business Council's 2023 report, Seize the Moment, pointed to Australia's falling economic dynamism, which we argue is the secret source of productivity growth. Sadly, though, Australia's corporate landscape is laden with a heavy regulatory burden, rising risk aversion, increasing policy uncertainty, and below average foreign direct investment. Business drives dynamism in the economy through investment and innovation. A lack of dynamism impedes productivity and makes it harder for Australia to move to the global frontier. The cost manifests itself by capital and labour being marooned in activities that are less productive than otherwise would be the case in a more dynamic corporate environment. Mergers are a critical aspect of ensuring competitive capital markets and a more productive economy. The market for corporate control puts pressures on managers to continually improve their businesses and creates opportunities for entrepreneurs to sell their businesses to others that are better placed and better capitalised to grow it to the next stage. As highlighted in the BCA submission to the committee, the design and execution of the Australian government's merger reforms are critically important to all Australians. A well-functioning regime will foster confidence in investing in Australia with appropriate guardrails to prevent the degradation of competition. We should all want this. But a poorly functioning regime would add cost and red tape and could lead to a loss of confidence to invest in Australia, increase regulatory and transactional complexity, and limit Australia's economic growth. This would come with great cost to society. The BCA considers the improved legislation to be a useful step in the right direction compared to the original merger's proposal, and presents an opportunity to achieve greater certainty, more simplicity, and increased timeliness for merger proponents. These are significant national reforms, the biggest in half a century in this space, but the proof of the pudding will be in their implementation. The BCA strongly advocated for measures that have now been included in the revised design, including retaining the ability of progress mergers with net public benefits, ensuring stop the clock and restart the clock provisions don't bog down economic activity, and having clear transitional provisions for business. Another key improvement in the legislation is the ability for merger proponents to put evidence that's responsive to material upon which the ACCC has relied, which will help ensure a fair right of reply to issues raised by the regulator. Where we still hope for improvement in the bill is in relation to how notification thresholds can be set by a legislative instrument, specifically that an objective and quantifiable standard be used. This is important to assist parties to comply with notification requirements and is consistent with international best practice. We have also made recommendations to improve the transparency and accountability of the merger regime for the ACCC's reporting obligations. Finally, we've noted our concerns about including land or an interest in land as a class of asset that will become notifiable for merger review. On this, we acknowledge the Treasurer's announcement to carve out acquisitions relating to residential property and certain commercial transactions, but we remain concerned about the practical operation of these notification requirements, given the often time-sensitive nature of property acquisition. Timeliness and transparency for the ACCC will be critical to ensuring deals that are good for the Australian economy aren't impeded by even more complexity, cost, and red tape. And so, subject to the passage of the bill, we will be engaging closely with the 12-month review on notification thresholds to carefully monitor their impact on the economy. The BCA recognises there are many details still to be worked through to support implementation. The further consultation, including ministerially determined thresholds, will be critical to ensuring the final details achieve the right balance. Thank you, Senator.
Thank you very much, Mr. Walters. And Mrs. Sutton, did you have a brief opening statement?
I don't today. I'm just happy to take questions. Thank you.
Oh, that's very helpful to the committee. Thank you very much. We'll go straight to questions. I'll start and then share the call with my colleagues. So just starting with the Business Council of Australia, it sounds to me from your submission and your evidence that you're supportive of the need for merger reform and supportive of the general shape of the reform, and that you're going to continue to engage as the subordinate legislation is consulted on. What do you see as the need that is out there for this sort of reform? You know, what are the problems with the current system, and how does the bill address the challenges that we see at the moment?
Oh, thanks, Senator. Look, I'll make some opening comments and then hand to Ms. Bailey, who can give you a more detailed answer. But we support many elements of the bill. We support the direction it's heading. Many of the things we've advocated for have been changed, as I made clear in my opening comments, I hope. So it's been a very big improvement on what was initially presented back in January. So in that sense, yes, we're supportive of the process. It's been a very constructive consultation process, albeit at times a bit rushed, with very short periods for consultation, which has been a little bit unfortunate, but we've managed, I think, to end up in a better place. So as a summary comment, I'd say probably we're supportive of where this is heading. It's come a long way, but we still require or hope for some improvements in those areas that I mentioned. But I might get Ms. Bailey just to go through some of those areas.
And just Ms. Bailey, just as you do that, sorry to cut you off there, just a little bit of evidence I think would be helpful to the hearing today on what the problems are that business face with the current model as well.
Thank you, Chair. Happy to address those points. Probably worthwhile noting when the original consultation for this commenced back in November last year, the BCA made a submission to Treasury at that stage, indicating that the existing merger regime, acknowledging that there are some challenges with it, was overall able to be worked with. That said, we also made clear that subject to a well-calibrated and evidence-based threshold and other safeguards for the regime, that we did not oppose the introduction of a mandatory notification scheme. Given that being our starting point, I think overall your characterisation that we are generally comfortable with the shape of the bill, I think it's fair. I think some of the benefits of the proposal is primarily around the transparency that this scheme will offer, obviously under the existing regime, particularly the informal merger clearance regime. There are elements of that process that are not transparent. I think the other benefit of the regime is that parties will have clear reason for the ACCC decision, and will also benefit from those reasons being made public for other acquisitions, which I think will overall assist business to understand how to engage in the regime. Finally, I think, particularly in relation to the informal clearance regime, there are no timelines associated with that. This bill provides a framework around the timeframes with which acquisitions will be assessed. And I think that will assist business have more confidence in how to bring their measures forward. So I haven't been exhaustive, but there are a number of examples of how the bill is assisted.
Okay, thank you very much for that. And I just wanted to go to the broader issue of divestiture powers. There's been some debate that the bill should include divestiture powers beyond powers pertaining to mergers, which the ACCC has available to them, and they've been used recently, as we know. But there have been calls in Parliament for broader divestiture powers around market concentration issues. What do you think the impact would be if there were further divestiture powers available?
Senator, I'll start and maybe Ms Bailey can add to my comments. Look, we are opposed to additional powers of divestiture. We think not only would they be unhelpful in this environment, but potentially harmful. Well, I draw your attention, as we have in our previous submissions to the committee, there's been several major reviews over several years, going back a couple of decades, the Harper Review, the Dawson Review and the Hilmer Review. All of them consistently recommended that there's no need to change the divestiture arrangements, that in fact they could actually make the outcomes for consumers worse. I could go into a lot more detail as to why we think that's a bad thing, in terms of which assets would need to be sold off. Is it a great idea to have a court determining which assets be sold off rather than for example, the government? There's all sorts of fraught space here, but to summarise, no, we oppose any additional changes, and we sort of agree with those findings of those previous reviews, and they were very rigorous inquiries conducted by eminent economists and specialists. We sort of defer to their advice that divestiture powers don't need to be strengthened.
Sure, happy to add to that, and simply to further reinforce the point that Stephen has made, is that under the existing misuse of market prohibition, there are very hefty penalties attached to that. And so we think that And as the Harper review drew out, that those penalties are an appropriate disincentive. And I think fundamentally there is a challenge with a general divestiture power in having a clear nexus between whatever harm has occurred, what particular assets are divested. This stands in contrast to our views around divestiture in the context of mergers and acquisitions as a penalty for prohibiting Section 50. Obviously, the assets around acquisition are more clearer than just an arbitrary blowing up of the assets of a business generally.
Yeah. Just finally from me before I share the call with colleagues, you've said today and in your submission that there's been a good consultation process. I heard you say today that at times it was faster than you would have liked. Changes have been made to the bill to from exposure to now to accommodate feedback. You've flagged that you want to continue to engage, particularly around targeted notifications. There's an understanding that, of course, once the bill passes, there's a need to consult further around the subordinate legislation, including targeted notifications. The regime is set to start from January 2026 with some implementation timeframes in the second half of next year. The bill obviously needs to be passed by the Parliament for the subordinate legislation consultation processes to commence in advance of the regime beginning. On all of that basis, are you supportive of the primary legislation passing in a timely manner, of this bill passing the Parliament in a timely manner?
I'll make some opening comments again, Senator, and then maybe pass to Ms Bailey. Look, on your comments about the consultation process, Ms Bailey's been the BCA's representative and all that, so my understanding is it's been a very constructive process, and as I mentioned in my opening statements, that quite a few significant changes we advocated for have been addressed in the revised legislation, so we're happy with that. We're certainly happy to be engaged ongoing because we think there's scope for further improvement, as I suggested earlier. In terms of supporting the bill, well, we're not in a position yet, Chair, to say we support the bill in its current form because we still are hoping many of those changes are made. As I said earlier, we're very supportive of the direction, but I'm not in a position to say that we support the bill in its current form.
Okay, and did you just referenced Ms Bailey making further comments? Did you wish to add anything there, Ms Bailey? No, that's okay. That's all right. Thank you. I'll share the call. I'll go to you, Senator Smith.
Thank you very much, Chair, and thank you for witnesses for making their time available. To the BCA, have you quantified the economic benefits of the new mergers regime for the Australian economy?
We have not, Senator. Look, we don't have that sort of detailed modelling capability. I wish we did. Look, we don't think it's particularly harmful, if I can say that, but your question is about quantification. No, we haven't done that.
When people talk about productivity, poor productivity outcomes in the Australian economy, they often talk about technology adaptation, they talk about corporate taxation, they talk about challenges in the education system. I'm just interested from the BCA's perspective, if we think about productivity improvements in our economy, proportionally, how important is merger reform?
It's right in the mix, Senator, because if you get, if for example your merger regime is too onerous, you don't get capital, and you mentioned technology and ideas flowing to places where they're more productively used with more efficiency, for example, then that is a drag on productivity. So it's sort of an overarching concept, I suppose. And you mentioned some of the things that have caused our productivity perhaps to be pretty poor, frankly, over the last decade. I could extend that list quite substantially if we had time. I won't do it now. I can, if you're interested, I can provide further information. But mergers is in there.
What I'm interested in is sort of proportionality. When we think about the effort that has been put into this particular reform initiative, what is the proportionate gain in terms of productivity gains, economic performance, etc. But you've said you've not been able to calculate that. When do you expect? When does the BCA expect the new regime to be mature? So there is the 12-month annual reporting review mechanism. But when would you, if the bill is passed, and I notice your qualifications, but if the bill is passed, when do you expect the regime to be suitably mature?
I'll get Ms. Slater.
It's not going to be mature from day one.
No.
Good morning, Senator. It is hard to know. It is ultimately, and as our submission sets out, it's hard to form a view on the bill alone because there is so much detail that will go into the legislative instruments, and those will materially impact the operation of the regime. In addition to that, the manner in which the ACCC is a steward of the regime will also influence its performance. I imagine there will be a process, as you allude to, an initial period where people are figuring themselves out in the new regime. And we know that there is a lot of work to be accomplished in order for the voluntary scheme to commence middle of next year is currently proposed. In terms of when we would expect the ACCC or the overall merger regime to be mature, it is hard to say, but I know that there appears to have been a significant allocation of resources, and I know that this is an area of priority for the ACCC. So we would hope that they get there as quickly as possible. Obviously, the 12-month review that's been proposed by the Treasurer, but also the 3-year review, and so it would, obviously we would want it to be mature as soon as possible because, as Mr. Wolf has pointed out, if the scheme's not executed properly, it will have a detrimental effect on the economy.
So in your submission, you have clearly proposed an amendment to the bill. And then there were two other, what I would characterise as significant qualifications. One in regards to the objectively knowable criteria around the notification threshold issue. And then secondly, the reporting of data around the use of the stop the clock and start the clock mechanisms. How significant to the BCA are those two particular points, notification, the qualifications around notification thresholds and the more granular reporting of the stop the clock, start the clock mechanisms, and what commitments have you had from the government in regards to those two particular issues?
Senator, in relation to notification thresholds, it is very important, though we note that there will be a subsequent consultation process on the instruments, and we will continue to advocate around a workable approach there. That said, it is international standard in that the International Competition Network has highlighted how important it is for thresholds to be formed on objective criteria. Ultimately, there are penalties attached to this. It's only fair and reasonable that parties know what they are obligated to notify and know when they are not required to. And so that amendment, we feel, will assist in achieving that. On the annual reporting around the performance of the merger system, we also think that's important. This is a significant responsibility, the operation and management of the administrative merger review system. We think it's appropriate that there's transparency around how it's being administered. Timeliness has been an important feature of the reforms of the government's intent and these stop the clock, restart the clock provision in addition to those timeframes, if you will. For example, you know, as you would be aware, if you stop the clock, that's not captured in the traditional timelines. And so we do think it's important that there is some visibility about how these are used. And also that will go to things like whether the notification forms, which are, if you would be aware, subject to legislative instrument as well, whether they are hitting the mark, whether they need to be refined in order to reduce the need for stop the clock provision, reliance, etc. So we think that is an important feature, particularly when it comes to the review 3 years down the track from its operation to make sure that it's hitting the mark.
So reading your submission, I took those 2 points in addition to the formal amendment that you have actually proposed in regards to the market concentration issue and what sounds like a verbal commitment the Treasurer may have given you, but which is not reflected in the bill. And that verbal commitment is what I read at the base of page 4 of your submission. Have I understood that? Have I characterised that correctly? That you've got a verbal undertaking around the market concentration matter, but the bill still contains the market concentration definition. Have I understood your submission correctly?
Senator, with regard to that, the Treasury consulted on merger notification thresholds. At the time of the consultation, there was a proposed threshold that dealt with market concentration. We advocated that should not be included, and in the Treasury's announcement, that was not included. So whether that means a future threshold, if it was revised, would contain it, I don't know.
I'll just check, Senator Smith, whether Senator McKim has questions, and I'll come back to you to conclude your line. Do you have questions, Senator McKim?
Yes.
You'll see that we're over time. So, Senator Smith, sort of last area of question.
Yeah, so just on this one particularly, because your submission says nonetheless, these issues should be addressed in the bill itself. So I have read that as a necessary amendment because the market concentration matter is contested in this particular, in our domestic regime, but the matter is settled internationally is how I've understood the issue thus far.
I couldn't say there are regimes that refer to market concentration. However, the International Competition Network, which is a reputable body, indicates the notification threshold should have objective, quantifiable criteria.
That's right. That's my understanding.
Thank you.
If time allows, I have some other questions, Chair.
Yeah, thank you, Senator Smith. Senator McKim.
Yeah, thanks. Good morning, folks. Thanks for coming in. Ms Sutton, I did have a few questions for you, please. Firstly, in COSBOA's submission, you stated that you understand the government intends to exclude acquisitions below $2 million in Australian turnover. From where did you get that understanding?
Apologies, that may have been misconstrued. I think where we're sort of coming from is talking about, I think the $10 million threshold has been mooted as again, in other consultations around the threshold mergers, and probably one of our concerns was around smaller acquisitions in local markets where, say, the turnover is only, $1.5 million, that some of those smaller acquisitions might not be picked up, but they could have impacts on concentrations in those smaller markets. Apologies, the wording might not have been very clear there.
All right, thanks. And just in your answer or your response then, are you talking about what's known as creeping acquisitions?
Yes, correct. So, I think there's been some examples where the ACCC has, used its divestiture powers to, correct some things that have happened in mergers subsequent to an acquisition proceeding, or as a means for an acquisition to proceed. But yeah, it'd be in those creeping acquisition space, and not necessarily, within 3 years may not have hit the $10 million threshold. So,
all right, thank you. Do you think the thresholds in general terms that are proposed are appropriate?
Oh, I think we're just heartened by the fact that the minister, regardless of the threshold size, I mean, obviously a lot of small businesses aren't going to be impacted by those thresholds, and nor do they necessarily want to notify. But we're just heartened by the fact that, the minister has discretion, and the ACCC have, putting time and resources into analyse certain industries to ensure that competition is protected in those local markets where it needs to be.
All right, thanks. Do you think the 3-year serial acquisition threshold is long enough?
That's a good question. I think it will be useful. What will be useful as we get more transparency around the kind of acquisitions the ACCC are notified to the ACCC. It'll be useful to have that review period. I mean, I think one of the issues currently is there's not a lot of transparency about what goes on behind the informal regime unless there's a statement of objection. So it will be really helpful to have that transparency. And then probably we would have a better response as to whether that's a long enough period or not.
Thank you. And just because of time constraints, I'll be really brief, but just one area for the BCA, please. And it's around the control exemption. Sorry, do you understand what I mean by the control exemption? Yep. Right, thank you. I note that the control exemption was not in the exposure draft of this legislation, but it is in the final draft. Did the BCA submit to the government that the control exemption should be included as part of the consultation process around the exposure draft?
No, we did not.
Okay, so what do you think about the control exemption?
We don't have a position on that.
All right, thanks. Thanks, Chair.
Thank you very much, Senator McKim. That concludes the time that we have for this panel. So thank you very much for being with us today and answering our questions. You go with our thanks. Thank you. I now welcome representatives of the Tech Council of Australia and the Australian Information Industry Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today? We'll start with the Tech Council.
Hi everyone, Damien Kasabji here, the CEO of the Tech Council of Australia.
Good morning, and we'll go to the Australian Information Industry Association.
Sorry, there's two of us, appearing for the Tech Council.
Apologies.
No, all good. My name is Madeline Houghton. I'm a policy manager at the Tech Council. Thank you all for having me.
It's okay. And just for double confusion, I think you might have a different name on your screen. Sorry, could you say your name again?
Madeline Houghton.
Oh, yeah, correct. Very good. Thank you. And to our next witness.
Sure. My name is Siu Lee and my last name is Xiao. I am the General Manager of Policy and Media at the AIIA. My screen is showing that my video is on, but please let me know if you can't see me and I'll figure out how to get it.
Thanks, Ms. Xiao. We do not see you at the moment, but that's fine. We can hear you, and Secretariat may be in touch with you to sort that out.
Sure.
I'll just go to you, Mr. Kasabji. Do you have an opening statement that you'd like to give?
Yes, I would. And look, I mean, we should also mention that Madeline is extra ACCC and an expert in the field. So I will have an opening statement that kind of goes through the Tech Council's positioning on this and how we think about tech in general. But we also have a very, very smart expert on the call that can help with any of the questions that you may have. But first of all, thank you, Chair, and thank you, Senators, for having us here. The Tech Council is very happy to be contributing to this discussion. We, as many of you know, are a strong advocate for growing the sector in Australia. Our organisation has set clear goals around jobs, 1.2 million jobs by 2030. It's a bipartisan approach. And we hope to create $250 billion valuation of the sector by 2030. We believe Australia is best placed in the world to start and scale a tech company, and we're seeing many success stories come out of Australia, not just homegrown success stories, but startups that have also been bought out by multinationals, which I'll go through today. We believe Australia's path to improve productivity and managing living costs is through policies that promote innovation and economic dynamism. Achieving these goals brings widespread economic benefit, extending beyond the tech sector. With the right policy settings, the Australian tech sector can continue to advance prosperity, foster competition and create high-value jobs. At the end, we agree with the Treasurer that these proposed changes represent the most significant reforms in Australia's merger laws in 50 years, and it is vital that these are implemented carefully to support Australia's economic future. It's important to also note that mergers and acquisitions are essential to a thriving technology sector. They have empowered Australian companies to compete globally and become tech success stories, and that includes a lot of our members like Atlassian, Canva, Seek, REA Group, Car Sales, among others. Mergers and acquisitions are also a powerful incentive for innovation and growth, paving the way for new startups to emerge with lower R&D investment and funding gaps compared to other countries. Australia's startups often rely on merger and acquisitions to achieve investor returns and drive sustainable growth. Put simply, a strong merger law are core to Australia's global positioning as a leader in the digital economy. The government should continue to incentivise founders to stay in Australia, to employ locally and to continue to contribute to our economic growth and complexity. Putting barriers to M&A activity, including acquisitions of startups by major investors, creates a chilling effect for local innovation and incentivises founders to flip overseas. Each tech startup flip represents a loss of intellectual property and sovereign capability and undermines the good work of government in helping founders create and commercialise their ideas in this country. Fundamentally, startup founders want to be based in a country where they have the greatest opportunity to be acquired. The greater the scale of a startup, the greater its impetus becomes. The Tech Council submits that the incentivising tech companies to remain based in Australia and to be acquired in Australia gives us a great opportunity to realise the network effects of local innovation. And this includes acquisitions of Australian startups by multinationals. Google Maps is a great example of a startup that was started here in Australia, which Google acquired. Google didn't necessarily needed to acquire the Australian company. There's lots of mapping services around the world, but there was a company in Australia called Where2 that was acquired by Google. Now, what that has done for Australia is ensure that the innovation around Google Maps is supported here in Australia globally. Google employs around 3,000 people in Australia working on that particular product. The TCA supports the government's goal for Australia's merger regime to be faster, simpler and stronger. We also support the intention in the explanatory memorandum that the process would be streamlined. It would be a streamlined process for the review of acquisitions. The shift towards a formal merger regime aligns Australia with other jurisdictions, potentially offering better clarity on when to notify the ACCC and the expected timeframes for merger reviews. This change would increase the efficiency, predictability and transparency for all stakeholders. We acknowledge the significant improvements that have been made during the consultation process. However, there are a few things that we wanted to just raise today. One, notification thresholds being set too low, potentially capturing nearly every acquisition made by an Australian technology company. This could lead to over-notification to the ACCC, causing delays and stifling investment. Number two, extended delays arising from the ACCC's discretionary power, particularly in the Phase 2 assessment stage. Three, changes to the substantial lessening of competition test, where the focus will tend to shift the focus away from actual changes in competition to simple increases in market share, reducing the relevance of this assessment. Additionally, procedural concerns such as broad ministerial discretion to set target notification thresholds and an inappropriate penalty regime and third-party appeal regime. Together, these issues risk introducing some complexity and uncertainty to the merger review framework, which we're happy to speak further about today. We believe that Australia can be the next place for an Atlassian, Canva or Afterpay. This is the new kind of increase in wealth for Australia. It is the place where our economy is becoming more complex. Only 10 or 15 years ago, there was only one or two Australian tech companies worth $100 million or more. We now have over 100 companies worth $100 million or more and 20 companies worth $1 billion or more. So we are thriving. We want to grow. We want to see incentives in our marketplace. And we thank you for having us here today.
Thank you very much, Mr. Kasabji. And Ms. Xiao, did you have a brief opening statement that you want to give? Thanks.
Yes, I do. Fairly brief. So good morning and thank you, Chair and members of the Senate Committee. The AIA broadly welcome the Treasury Law Amendment Bill, acknowledging that it has already made some positive changes following the last consultation. So notably, the bill does enhance some clarity around the ACCC's assessment timeline, which is much needed, predictability and efficiency for merger reviews. And by limiting its capacity to stop the clock during reviews, it has created a system that's more in tune with the pace of modern business needs, especially in the tech sector. And we also would like to call out quickly the addition of the public benefits test offers a balanced and independent approach to reviewing the ACCC's disallowance decision, an element we support given the economic and productivity benefits in tech innovation. So while the bill represents substantial progress, the AIA remains concerned about the use of a uniform monetary thresholds to regulate mergers and acquisitions across diverse industry and asset classes. Such a set of inflexible monetary threshold fails to capture the unique nature of the M&A activities within the tech sector, where innovation is frequently driven by the acquisition of small startups. Many of these small firms are not established to operate as a standalone businesses, but to develop specific features that integrate into existing tech services. The inability of larger tech firms to acquire these small specialized startups due to the rigid thresholds could render the Australia as a less attractive environment for innovation and growth within the tech sector. Moreover, the inclusion of a substantial lessening of competition tests poses additional concerns for the tech sector because it could include the consideration of market concentration. Unlike traditional industry, tech sector faces strong, fierce competition and low barriers or relatively low barriers to entry, which shift the competitive landscapes rapidly. For instance, unlike the supermarket sector, where a 90% market share suggests a significant competitive risk, a similar share in the tech sector might be short-lived. As seen in companies, and I apologize to these companies as examples, but BlackBerry, MySpace, Yahoo, which once dominated the market but was swiftly overtaken. To ensure the effectiveness and the relevance of this legislation, the AIA proposes the following: a regular mandated review of the ACCC's processes and timeline with transparent reporting on efficiency and alignment with the objectives of fostering competition, sector-specific thresholds that account for the distinct characteristics of different industries. Such thresholds should be defined through consultation with both the Treasury and industry experts to ensure they are evidence-based and appropriately targeted and financially modeled. Finally, we urge timely reviews of these thresholds, keeping pace with the fast-changing dynamics of the tech sector to prevent regulatory lag from stifling innovation. I would also add, like my colleagues in Tech Council of Australia, we're also a bit concerned about the broad discretion of the minister in calling for a review as well, and we would like to just have more certainty / transparency on how those decisions are made. We believe these recommendations will support a regulatory framework that protects competition without hampering Australia's potential for technological innovation. Thank you for your attention, and I look forward to our discussion.
Thank you very much for the opening statement there and for your evidence. I'll just start with some questions for the Tech Council. And you've said that you support the goal of a faster, simpler, stronger merger system in general. I just wanted to go back to some of the challenges of the current system, which many people have, described as very slow, very uncertain, in terms of a voluntary notification system that, then relies on the court to make determinations. It's an opaque system with a lack of reporting and transparency, and there's been criticisms that it doesn't, allow mergers that perhaps don't, benefit the economy. Are you able to give us some evidence, some assessments of how the current system is playing out in the tech sector?
Yes, Senator, I'm happy to answer that. There are two key concerns, I think, around the current merger review process, in particular, that have been raised with us. And I think these certainly go to some of the themes that you've already flagged. I think there are concerns particularly around the process of the current informal regime, that the way that it is operating is there is a lot of uncertainty and it lacks transparency. In particular, I think some of the feedback that we have received from our members in particular has been it's very unclear as to often when a merger should be notified to the ACCC. And that this then, what often that means in practice is that notification becomes an issue with all due respect to the AFR when it becomes, a headline story in the AFR, even though ultimately it's not an acquisition that the ACCC is particularly interested in. Having clear thresholds set for when transactions need to be notified would really improve certainty for companies that really want to do the right thing in notifying to the ACCC or not. And the current system is very complex and uncertain for companies making that decision. The second area in terms of process, where the current system is perhaps not sort of working well for the tech sector is sort of, as you've already flagged, I think a lack of transparency and certainty around timing of reviews. You can see from sort of the ACCC's public register, there is a huge variation in length of time that merger reviews take. And this makes it very difficult to make transactions in Australia, where there's sort of an almost completely uncertain time frame for when you're going to get the ACCC's view on the acquisition. And so improvements around certainty of timing for the review is something that the tech sector would strongly welcome. In terms of the substantive assessment of mergers, I think that Section 50 has proven itself to be sort of remarkably flexible over the years to be applied across a very broad range of industries and sectors, including dynamic sectors such as the tech sector. And that sort of our members' comment is that Section 50 has proven to be remarkably resilient in dealing with sort of a large variety of industries and economic theories of harm when it comes to assessing mergers. And so the key concerns really more lie around the process features of the current informal regime. I'm sorry, Senator, I think you might be on mute.
Thank you very much for that assessment and for the muting advice as well. So I think you've said in your evidence as well that the thresholds and the targeted notification requirements that are going to come for consultation next are of interest to you. So I might just come back to that in just a second. But based on your assessment of the challenges with the current regime, do you support the faster timeframes and think that will be of benefit in this reform? So legislated timeframes and the sort of the greater transparency that's involved, and also I guess the certainty in that, you know, this is a movement to a mandatory notification system, you know, in line with the vast majority of other OECD countries. So are there elements of the reform that you think will be useful to give certainty and support the tech sector?
Yes, absolutely. I think in theory we do think that sort of the formal merger regime process can certainly improve the timeliness and improve certainty around sort of the timeframes for ACCC decision making. Our concerns, I think, with what is before us is that sort of there remains a wide margin for the ACCC, particularly in phase 2, to extend the timeframes quite considerably. And so there is still, especially in phase 2, quite a degree of potential for those timeframes to expand. And to introduce uncertainty into sort of the timing of the process. I think a lot of that sits around sort of the broad information gathering powers that the ACCC has. There are, as you would know, sort of considerable information gathering requirements for sort of starting a merger, sort of notifying the merger to the ACCC and providing upfront information gathering. And then we sort of get to phase 2 and the ACCC has sort of unfettered ability to make further information requests, and those have significant impacts on the timing.
Sorry, I did cut you off there. And in that sort of phase 2, a timeline has to be set. Yeah.
Yes. Yes. So I think so. The concern is just about the ability for that phase 2 timeline to blow out sort of considerably because through the use of those information gathering powers that the ACCC has, and that could undermine some of the advantages otherwise that a formal merger review process has.
Okay. And thank you. And I'll go to Senator Smith after I just ask this question. Can you just tell us a little bit about your involvement in the consultation thus far and whether you're intending to be involved in the consultation on the subordinate legislation, so the thresholds and the targeted notifications?
Yes, absolutely, Senator. The easy answer to the second part of your question is yes, we do intend to continue to be a part of this consultation. It's very important to our members and to the tech sector more broadly, and we'll continue to engage with it. To date, we have engaged both in sort of the original consultation process that Treasury conducted at the end of last year, and then on both the exposure draft and the proposed notification thresholds consultation that has occurred within the last couple of months.
And just rounding that off, there are a number of changes that were made from the exposure draft to this bill. And do you welcome those changes? And what were the most significant for you?
Certainly, Senator, look, we welcome many of the changes that have been made following the exposure draft legislation. I think of sort of particular note sort of to the tech sector was the change in the sort of articulation of the serial acquisitions piece, so that it now much more clearly targets horizontal acquisitions or acquisitions of sort of similar products or services, rather than the exposure draft contemplated serial acquisitions in terms of vertical or sort of series of unrelated acquisitions. And we were particularly concerned about the impact of that in the tech sector, given that sort of tech companies typically have no interest in acquiring sort of identical other tech companies. And that would have had a sort of very significant impact across the tech sectors. That's in particular one of the changes that we welcome. However, we do note sort of that there were improvements as well already that we've discussed about sort of the process and timing and sort of some limits imposed since the exposure draft on the ability for those timeframes to blow out significantly, which we welcome.
Great. Thank you very much. Senator Smith.
Thank you very much for your participation today. Should the bill be passed in its current form?
Senator, we consider that there's certainly further improvements that we think can and should be made. This bill does represent a significant improvement on sort of many of the sort of other various pieces of consultation so far and on the exposure draft itself. However, there are changes that the tech sector would wish to see made to this bill before it is passed.
Have either of your associations had an opportunity to quantify the economic benefit to your industry as a result of the proposed merger reforms?
Senator, no, we have not conducted that sort of analysis ourselves.
And Mr. Kasadi?
Thanks, Senator. We have not conducted that. Having said that, we've outlined in statement some of the areas that we continue to be concerned about, specifically around thresholds. We do think the intent here is on the Australian market and how the Australian market looks, especially when it comes to the grocery industry or other major Australian companies. What we are urging the Senate to consider is that the dynamics of the tech sector are global in nature, that when there are mergers and acquisitions, there is the assessment of the market is very different, that you think of Leonardo AI now has been bought out by Canva and now will have global leverage through its purchase, through that acquisition, and the innovation, the IP, the employees of Leonardo AI will be able to leverage that globally rather than just thinking about that from an Australian context. Similarly with Google Maps, where it's a multinational. So we have outlined the areas that we would like to see change in this bill for it to have our full support. And I think what I'm outlining here is kind of the psychological difference in relation to how not psychological, the practical difference in relation to how our industry operates and works at a global level, and the psychology of some of the language in the bill very much focused on this being only an Australian market.
You don't say this in your submissions, but are you arguing a carve out or a specific tech industry approach?
Look, I think that we have argued for notification thresholds that take sort of account of different types of asset classes. And so to that extent, there would be differences taken, Senator, for different types of assets being acquired. I think merger regime has operated well as principles-based legislation, but I think that the legislation has to be sort of sufficiently flexible to take account of these sort of broader global dynamics as well as sort of Australian-specific dynamics, and that this should be sort of part of the ACCC's consideration to consider sort of fulsomely the context in which the context in which companies subject of a merger notification operate.
Just last question, if you have one, Senator Smith.
Yep. And finally, at item 5 in your submission, which is headed, there is high likelihood of significant delays in the assessment of mergers and acquisitions. You explicitly state the tech industry's view that time kills deals. That's your quote. And then, you sort of do raise the alarm in regards to the ACCC's broad discretionary powers. How significant is that to your to the industry if these matters are not properly resolved as proposed in your submission?
Look, I mean, we have said very clearly we don't want to create or see a chilling effect through this legislation. I gave the example in
a chilling effect in terms of merger decisions and processes and even
Correct.
opportunities. Yeah.
Correct. And I gave an example in the opening statement that goes exactly to what you're referring to, Senator, where we saw, and a very, very kind of clear example, where Google would have looked for a Maps capability. When it was seeking a Maps capability, it could have chosen any company around the world. Web2, I think, from memory, was the name of the Australian company. It wasn't the only company working on mapping type services or digitizing mapping type services. Part of Google's decision around purchasing that company, which became an embedded part of one of its global products that we as Australians and Americans and everyone use around the world, was that this was an area that it could make that acquisition, keep the engineers in Australia, and have that product go global in an absolutely faster and bigger way than would have existed otherwise. The result is 3,000 employees in Australia. So what I'm trying to kind of highlight is that as part of decision making when it comes to global companies is which company should we buy that we can integrate, that we can highlight, and we can use our global presence to leverage. Which country should we look at? And one of the things that companies, multinationals, will look at is the local regime. The other way is also true. I should say, Senator, I think this is an important point, that most people and most companies that are members of ours who started a company, one of the ways that they see success is being bought out. So you can become a unicorn, you can become a $1 billion company, but from the absolute onset, if you are working in a garage, you've got a new idea, you're taking a lot of risk, you've got some VCs backing you, you're using your own personal money to start a business, one of the success metrics is, can I create a company that is attractive enough for another company
It is part of the incentive. Similar point, Chair. Then I'm absolutely done. At what point would you be at? So let's assume, for the sake of this discussion, that the new regime was to have or did have a chilling effect. Over what time period would that become evident to your industry, do you think?
Look, I think, Senator, the time period, it would become, I think, in sort of a micro scale, evident quite quickly. These are dynamic markets, they move very quickly. I think it would take a longer period of time to be able to sort of accurately measure that. But it would
anecdotally, yes, I agree.
Anecdotally, become evident quite immediately.
Great, thanks very much. Thank you.
Thank you. That concludes the time that we have for this panel. We very much thank you for your evidence today, and you go with our thanks, and we'd ask that you now disconnect from the video conference. Thank you very much.
Thanks for having us.
Thank you.
Thank you.
Thank you. I now welcome representatives of the Competition Review Expert Advisory Panel, and I welcome Dr. Kerry Schott, AO, and Mr. Rod Sims, AO. Just for the Hansard record, and so we can make sure we can hear you both, would you please each state your name and the capacity in which you appeared today for the Hansard record, starting with you, Dr. Schott.
Thanks, Senator. My name is Kerry Schott, and I am the chair of the independent panel.
Thank you. And Mr. Sims? And you are currently on mute, Mr. Sims.
Thank you very much. Rod Sims, and a member of the independent panel.
Thank you very much, both, for making yourselves available to the committee today. Did you have any opening remarks that you wanted to give, or are you happy to go to questions?
I might just very briefly, Senator, say that the work of the panel was really helpful, I think, in two areas. The first was the international expertise that Professors John Fingleton and John Asker brought to the committee. John Fingleton from the UK and Ireland experience in regulation of ACCC type matters, and John Asker particularly from the US. So we were very aided by their intimate knowledge of those jurisdictions. And the other thing I think that the panel brought that was helpful for Treasury was a real world view of the way that business operated, and that came particularly through Sharon Hendrick, who's a lawyer who's operated on both sides of the merger equation, and David Gonski, who is would be known to the Senate, and to a lesser extent myself. But I think that practical experience was quite helpful. And of course, we had Danielle Wood with economics background, par none, and Rod with his experience in ACCC. And that's really all I'd say by way of introduction. Thanks, Senator.
Yes.
Sorry, I'll be very quick as well, but I just wanted to step back a bit and just obviously state the obvious that Australia has an extremely concentrated economy. It's always much discussed. Supermarkets, ticketing, energy, transport. And I think the economic literature is clear that that level of concentration reduces productivity, it reduces wages, it increases prices, and it reduces economic growth. So it's a real burden on the economy. In my view, Australia's ineffective merger laws are partly to blame for that, because after all, that's where the concentration often happens. And we've seen that through a number of mergers that have been contested, and we've seen that through mergers that didn't get looked at or contested. To me, there's sort of four problems with the current merger regime. First of all, the ACCC doesn't see all the transactions, and I've been stunned as we've gone through this process how many transactions the ACCC hadn't seen that it wasn't aware of, obviously, that it hadn't seen. And so a mandatory system, I think, is, as the rest of the world largely has, is very important. Secondly, there's enormous pressure on the ACCC time-wise, because often the merger parties have been planning the merger for a very long time. They're all ready to go to court. The ACCC only hears about it at the last minute. And so quite often there's pressure on the ACCC, look, make a decision or we'll take you to court. The company's prepared for court, the ACCC's not. Thirdly, there's just no way of dealing with creeping acquisitions effectively at the moment. And fourthly, and I think this really is the strongest point, that a first instance courtroom litigation just does not work where you're trying to get evidence that something's anti-competitive and that thing hasn't happened yet. It's a merger. It hasn't happened. So that works fine when you're dealing with cartels and misuse of market power and things like that, where the event has happened, but in a merger it hasn't. So I think, to sum up, overall, this new regime will bring a lot more economics to bear. We'll get better economic outcomes for the economy. So I really think it's a very welcome change. And I'm just delighted that Parliament is considering this so quickly, because obviously I think there's a lot of expectation around this regime, and that creates uncertainty. So I'm just delighted that Parliament's looking at this as quickly as they are. So thank you very much.
Thank you very much, Mr. Sims, for that. I've just got a couple of questions, and I'll share the call with my colleagues. Dr. Schott, Mr. Sims has just described 4 problems with the current merger system. I was wondering if you had any perspectives for the committee from a sort of a business perspective about what's some of the current problems for business in the current merger regime that we have, that's obviously been described as slow and opaque and uncertain.
It's certainly slow and opaque and uncertain, but it's also extraordinarily expensive because of the legal costs that mount up, and the outcomes are very uncertain. So I think the thing that's important about mandatory notification with the thresholds that have been set is that the ACCC should get more economic resources to look at what's coming through and deal with things very quickly. And our expectation certainly is that by far the majority of notified mergers will be in and out of the ACCC very quickly, so within that first 15 days. And I noticed, I think, that the government has increased the resources substantially for the ACCC to hire the extra people it's going to need to do that. one of the things that as business we notice is we're going through enormous transformation in the economy, as we all are experiencing. And the serial acquisitions that Rod mentioned are a huge concern and a concern for our consumers. There's been small pathologists and regional abattoirs sort of gobbled up by large companies and become very large companies, and it happens really before the ACCC has even noticed. So you get what's an elephant growing that nobody even knows is even a baby elephant until it's there. And a lot of that we were concerned about. The other area is the huge increase in unlisted companies in Australia. And unless you're listed on the stock exchange, the ACCC at the moment really has very little vision on what's going on in that unlisted sector. And it's a growing sector and there's nothing wrong with it, but it does need to be notifying so that there's more transparency, I think.
Mm. And is the framework, and perhaps this is a question for both of you, is the framework that the government has arrived at through a long process of consultation as well, is it broadly a faithful reflection of what you wanted to see as your expert advisory panel looked at this issue, and I understand a broader set of competition issues as well. But do you see the bill broadly as a faithful reflection of what you would have wanted to see?
Yes, it is, Senator, and there were matters of judgment in it. I think particularly around the thresholds that are proposed. And I'm very pleased to see that there'll be a review of how things are going in 12 months. And then, of course, the usual statutory review some years later. But I think that gives us a chance to actually assess how things are going. And our preliminary assessments are that those thresholds look all right. That was probably one of the areas of the main judgment calls we made. I think I'll leave it to Rod to add anything else to that.
Thank you.
Oh, just briefly, I've had a reasonably quick look at some of the submissions, and it just seems to me that there's been an enormous amount of consultation, which obviously the expert group's aware of, and going through those, particularly the Business Council, you can see that there's been a lot of consultation and a lot of taking account of concerns. I personally remember the changes to misuse of market power, Section 46, where every element of the business community said the sky would fall in, and it didn't. I think on this occasion, you're getting a strong level of support. Obviously, people raise particular issues, but I think the consultation on this has been extremely well done by the Treasury group, and that shows in the submissions.
Thank you very much, Senator Smith.
Thank you very much, and thank you both for your participation today. Is the proposed new merger regime risk-free?
In what sense, Senator?
Some of the submissions have talked, so for example, the Productivity Commission in its submission talked about possible risks in regards to excessive financial or administrative costs. Some submitters have talked about possible delays as a result of the start the clock, stop the clock mechanism. So curious to know in your consultation work, now that you've seen the bill, is it risk-free? If it is risk-free, that's great. Time will tell. If it's not risk-free, what are some of those risks that currently exist in the proposed regime?
Oh, thanks, Senator. Look, the risk that I personally was most concerned about was the one of implementation. This is a really major reform for the ACCC and for the legislation, and much overdue in my view. But implementing a change like this comes with risk, and I was pleased to see that Treasury had appointed an expert to assist with that implementation process, both at the ACCC and with themselves. But I think any change like this is going to come with that sort of risk, and I can see that they have done things to mitigate it. And I think, as I mentioned earlier, the review process in 12 months' time will help with seeing how it's travelling. But it is very important that the timelines are pretty much kept to what we expect they will be, and it's very important that the ACCC get the additional resources in place that it's going to need to become much more economic and industry focused than focused on very technical legal matters.
I would just add, Senator, that there's always risks associated with everything, including crossing the road. If you buy a packet of Panadol, it's going to list a whole lot of risks, essentially, which won't come about. So I think it's one thing for the Productivity Commission to do their job, which is to outline things like that. It's a separate question of whether any of those risks will actually arise, and in my view, they won't. The only risk of delay, I believe, is with mergers that are potentially anti-competitive, which the ACCC is not seeing at the moment. They will get delayed, but in my view, they should get delayed. So I don't see any delay at all in mergers that don't have important competitive implications. The system for getting those done quickly doesn't change under this regime. In essence, they can be dealt with within a couple of weeks, as they've been done in the past. And whatever increased resources the ACCC's got, it's still going to have to. Those resources are going to have to go on the ones they want to have a close look at. The ACCC's got every incentive to get rid of the ones that it doesn't want to look at very quickly. So I don't think there's a delay issue, except if you've got a problematic merger, which you weren't otherwise going to tell anybody about.
Thank you. Dr. Schott, in your remarks just recently, you talked about judgment calls being made around the threshold issue. Could you give the committee a bit of an insight into some of those, some of the tensions around those judgment calls in terms of landing at appropriate threshold levels?
I wouldn't say there was any tension, Senator. It was just more of an issue of where the actual number should sit. Is 200 million the right number, or that's where we landed, but it could have been 250 or it could have been 150. It's just it felt about right, but that's the sort of judgment I was referring to. And I think whatever number you land on, it's going to be pretty close to where we landed, I think, as being the right one. You don't want things happening that the ACCC is never seeing that it should have seen. So I think we were about right. We did have a big discussion about those thresholds, and that's really where the main judgment was.
Do you both have a view about when you expect the regime to have matured to a level of confidence for participants?
I think the fact that it sort of almost kicks off in the middle of, on present timelines, in the middle of 2025 as a sort of trial run, if you like, and then by 2026. So certainly I think by the end of calendar 26, it will be becoming very apparent that it's doing what we expect it will do?
Mr. Simpson.
I would only add. I would only look. I don't think it'll take that long, Senator, because the extra economic look at things is directionally what's happening now. This will just allow that to happen in a better way. I'd also add that the system coming in is one that's being used largely around the world, and the ACCC is in constant contact with overseas agencies to learn from them. And many of the legal practitioners, not to mention the companies, operate around the world. So I think it's not as if we're inventing something new here. We're doing what's done overseas, and I think a lot of those lessons will come in, and a lot of people will bring those lessons here because they're familiar with that.
Chair, I think you'll probably want to go to Senator McKim. If time allows, I have some other questions for the.
Thank you, Senator Smith. Senator McKim.
Thanks, Chair, and hello, folks. Thanks for your attendance today. I wanted to ask about the control exemption, which wasn't in the exposure draft, but is in the draft that's been provided for Parliament, and that's basically where the bill provides an exemption from the mandatory notification requirements for acquisitions of shares that do not or would not result in the control of or in control of the target. I do note the ACCC has expressed some concerns about this in its submission, although I do acknowledge that there is a provision for the Minister to determine by legislative instrument a class of acquisitions that are required to be notified and will not be able to rely on the exemption. But I'm just wondering if that issue came up at all in the work that you've done, and whether either of you had a view on the provisions that have appeared in the version of the legislation that's been tabled in Parliament.
Senator, yes, it did come up in our deliberations, and most of our feeling about it was that keeping control as closely as possible to what it is currently in the Corporations Act would be helpful for everyone, where it's understood. But there are economic circumstances where those definitions are not particularly applicable, and we did discuss a number of those areas. It's actually it's very clear when there's no increase in control, but it's not always very clear when to define it, if I can put it like that. Rod, you might add to that.
Oh, look, it is a complex issue, and there's always a bit of give and take, Senator. I think where they've landed is a good place to start, and this is something that can be looked at, but it's pretty similar to the approach taken now. So I'm not concerned about it, but if it turns out to be a concern, then this is something the review can pick up. So I think it's been a result of the consultation, and I think that's a positive that that consultation has been listened to and adjustments have been made.
Did you recommend the inclusion of such a provision?
I don't. My understanding is, and look, Kerry might add to this, but my understanding is it was something that was discussed and that we were comfortable with, as distinct from go away and come back and recommend. So there are a range of changes made in response to the consultation, which we were aware of and I think comfortable with.
Yes, that's right. It was. We were comfortable with where it ended up, Senator.
All right, thank you. The chair of the ACCC, Ms. Cass-Gottlieb, has previously said that she thought the ACCC should have call-in powers, and she's also said that the onus of proof should be reversed, so that basically companies have to show why a merger isn't anti-competitive. Now, neither of those two things have been provided for in the legislation. Do either of you have a view about either of those two matters?
Senator, I have quite a strong view about the call-in powers. I think it is. I think it is the job of the ACCC to make its mind up about whether or not a merger is competitive or anti-competitive, or definitely anti-competitive. It is not up to the business players to be making that call at all. So that was an area where the panel took a line that was opposite what the ACCC would have liked to see.
I think, Senator, just to add, the fact that the Section 50 still applies is a good response to the call-in power question,
Yes.
and I think largely addresses that. Look, the reversal of onus of proof, Senator, that's one that's been around on all sorts of legislation, not just the ACCC legislation, but just everything that moves. And clearly, if you're the regulator, that's what you'd prefer. And if you're the corporate sector, you don't like it. So I think where they've landed, where it's landed is absolutely fine. Let's see how it works. It's this is an important change. Changing the onus of proof will just be layering another change on another change. I think let's give this a shot and see how it goes. I'm confident it's going to lead to much better outcomes.
All right, thanks. Perhaps I could just, in regards to the call-in powers, why should the regulator not have call-in powers? What's the argument against call-in powers for the regulator?
Actually, I don't think under these changes, I don't think the ACCC, frankly, really needs it, because there's notification of mergers above the thresholds that have been set, and there's really not going to be much that's anti-competitive that could be happening that they're not going to get a look at. So I think the argument for call-in powers would certainly be strengthened if you didn't have mandatory notifications. But I think with mandatory notifications, Senator, it's not needed. And I think the retention of Section 50 also, does give you more protection.
And just jumping in there, if I could, Senator, very quickly, given the thresholds, the ones that don't get caught by the thresholds are by definition slightly smaller firms, and the ACCC, if it knows about them, can deal with them under the current Section 50. The only difference is it would call them into the formal process versus deal with them under the existing Section 50. I think, given that you're dealing with smaller companies, that will work fine. They don't have usually the resources to do what the big companies do to get around the merger laws. So I really don't think it makes any difference now that we've got Section 50 retained.
And I think, Senator, with the smaller companies, the serial acquisition parts of the change pick up a lot of the concerns that the panel had.
All right, thank you. And last question from me, Chair. Thank you. In Senate estimates previously, Ms. Cascott-Leib, when we were discussing potential thresholds, indicated that I'm trying to be very careful not to verbal her here, but
to join us if you ask a question.
I know Ms. Cascott, I know the ACCC are in a moment, but basically raised the potential of a threshold relating to the value of a proposed transaction, whereas the thresholds that appear to have been served up around turnover are generally turnover-based thresholds. I just wonder if I could ask you what is the what your view is on thresholds based on the value of a proposed acquisition or a proposed merger, as opposed to thresholds based on turnover. So not so much the level of those things, but what the difference is in those, and what the difference in effect will be of having thresholds based on turnover as opposed to thresholds based on the value of a proposed merger.
I think two things, Senator. The thresholds based on turnover are very easy to measure and are simple. And the minute that you get values being used, it calls into question how you value. And as a investment banker in my past life, I'm quite dubious about what valuations actually mean once you start getting into complex businesses. And I would really, I really think you would find yourself in a landmine where you're arguing about whether that value number actually is the value. And I do think that the turnover is just much easier.
Okay.
Thank you.
Thanks.
Thank you, Senator McKim. Thank you very much, Dr. Schott and Mr. Sims, for your evidence today, and also all of the work that you did leading up to today. Thank you, and you go with our thanks.
Thank you very much
for all you're doing. Thank you.
I now welcome officials from the ACCC and the Department of the Treasury, all there in Canberra. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. And as you make your way to the table there, the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I will ask you for the Hansard record to please state your names and the capacity in which you appear today. And perhaps Ms. Cass Gottlieb, we could welcome you and ask you to do that procedural introduction for us.
Thank you very much, Senator, and good to be with the committee. I'm Gina Cass Gottlieb, Chair of the ACCC, and I have with me Ms. Susie Copley, who is the head of our merger reform team and has been a senior head for over 20 years in our merger branch, and Ms. Jennifer Barron, who is our Deputy General Counsel, who heads the legal team within our mergers branch.
Thank you very much. And Treasury.
Marcus Betsy, Chief Advisor to the Competition Task Force.
I'm Jace McDonald, the Division Head for the Competition Task Force.
Annalisa Hager, Acting Assistant Secretary, Competition Task Force.
Jessica Robinson, Assistant Secretary, Law Division.
Thank you. I'm assuming that, as per standard procedure, that Treasury does not have any opening remarks to give. But Ms. Cass Gottlieb, did you have some opening remarks that you'd like us to hear?
Thank you. Very brief ones. The ACCC welcomes this bill. We have been seeking this reform and think it's much needed. Currently, every day, transactions are occurring across multiple key sectors in the economy, whether health services, infrastructure services, everyday household goods, like in the supermarket sector, liquor and pet products, which the ACCC doesn't get to see because they just don't get notified in this voluntary system. What the reform, when it's in place, will do is it will give assurance to the community that the ACCC can see and assess transactions that may pose risk and prevent the very small number of transactions that pose the most risk to competition, consumers and the economy. It will also, in fact, as every witness before this committee this morning has noted, will provide a more certain, timely, efficient and transparent process for business and for the wider community, and we are very keen to commence our engagement in a smooth transition and implementation as soon as possible. For this reason, we have issued our statement of goals for implementation with a set timeline of preparatory work and careful transition. So in summary, everyone so far has said the reform is vital, but it needs to be carefully designed and implemented. In my view, the close process of consultation has been a very careful design process, and I'm here and I know you're going to hold me to account today and going forward to tell you it's going to be very carefully implemented to deliver on being faster, simpler and stronger.
Thank you very much for that opening statement. I'll just ask a couple of questions and then share the call with my colleagues. You've gone to some of the challenges of the current regime, including the number of mergers and acquisitions that you're just not seeing and the community's not seeing, and the competitive challenges there. And you've gone to some of the benefits of this regime that's proposed in the bill, faster, stronger, simpler method. I wondered if you could comment on the question of the timeframes for mergers to be approved after being notified to the ACCC. Do you believe, as your suspicion says, that there'll be an improvement in timeframes for business?
Thank you. First, and Rod well drew out on the basis of his experience as well. Currently and in the future, we are assessing 85% at least of transactions and clearing them within 14 business days where they pose no or limited competition concerns, and we would continue to do so. The area there is most focus on, and we hear from business and we heard this morning, is on the more difficult transactions that involve a greater risk of competitive impact. And with those, the current, not only informal but not suspensory, so there is not a requirement to get approval before they can move ahead, and parties come to us when they come, frequently late and with insufficient information, which causes delay. The benefit of this process is that the parties will need to come with the proper information up front, with the form that will be one of the instruments that will be issued. In addition, the parties have all the incentives because they are waiting for our approval to fully inform us up front. Most importantly, though, the statute binds us to set timeframes. If we do not make the decision within the set timeframes, then it is deemed approved. So the clock is running for us and we must approve within the set timeframes. That does not occur now. But in addition, and I know, so I'll jump to it, and the BCA said it and the Tech Council also said it, there is a concern about the question of the stop the clock and start the clock. It will first be transparent because we will have to show it on the register every time we use it. But we are also very willing, and we will include it in our implementation plan, that we will commit to reporting on the use of that ability to extend. I should also say that there are details which limit our ability to extend. So there are safeguards also in the legislation, but we will report when we use that safeguarded and limited ability to extend, which is only where we have issued a mandatory information request and the party has not answered after 10 business days of issue. So we are limited. if the parties respond quickly, if they provide all the information up front, there won't be a need to use it. But we are very happy to report, as the BCA is asking, on the use of those extensions. So it will be a totally different framework, Senator.
Thank you. I'll just go to some of the questions that were raised today also about the merger notification thresholds. They've been announced by the government to help assist with certainty, although they are subject to subordinate legislation that will be further consulted. We'll have evidence in this inquiry that they're both too high and too low, and that is somewhat usual in Senate economics inquiries. In your submission, you say that a priority for the ACCC has been to ensure that the monetary thresholds are capable of capturing the types of mergers that have historically raised significant competition concerns, and you also go to some of the ways in which these are sort of, the model is broadly consistent with international experience as well. How do you reflect on the thresholds that we've arrived at?
We think the thresholds are appropriate and will capture the vast majority of transactions the Commission has identified in terms of their nature as high risk in the past. We are particularly pleased to have the additional targeted threshold for very large acquirers of smaller businesses or assets, because the data analysis done by the Treasury Task Force showed that the majority of acquisitions are done by the 1% largest companies in Australia. And that is why there is the additional targeted threshold for acquirers who have Australian turnover of at least $500 million. And that does examples of those sorts of transactions as supermarket acquisitions by the two large acquirers there of small independent stores, for example. We also consider that the serial acquisition aggregation is very important, and do note that there is the capacity for a Treasury Minister upon a proper due process, so to receive advice from the ACCC and then consultation, to issue targeted for particular sectors, specific additional requirements, and that is a process that, and as a disallowable instrument also I note, will be a transparent consulted on process, and one that Parliament of course will see in its usual manner.
Thank you. And on that, the Treasurer's speech on the bill says that it was on your advice, Chair, that the government intends to use the targeted notification hour so that the ACCC can review purchases of an interest above 20% in an unlisted or private company. What have you observed happening in the market that supports the need for that particular control test, and why have you advocated for it?
Thank you. Senator, first I will note we have also already given advice to the Treasurer in relation to doing an additional notification requirement for the supermarket sector. So that is one piece of advice that we have given the Treasurer, that these powers will be very important to be able to deliver. The second is that we have, and it references questions Senator McKim has been asking earlier, actually this morning. We have given advice to the Treasurer, and the Treasurer in his speech noted that he does intend to limit the control exception in the case of unlisted private companies, and which will include private equity. The reason we ask for that is this: listed companies and more broadly held public companies, which are Chapter 6 Corporations Act companies, have strong regulatory and transparency requirements under the Corporations Act, and we are satisfied that the current control exception subject to changes in control, for instance, if they go over 50%, as for example, but though that they are subject to a sufficient transparency that we will see what is occurring. However, private companies, and frequently transactions before us are by private equity. The Petstock example was an acquisition by a private equity fund. The acquisitions that are occurring in radiation oncology are by companies that are owned by private equity funds. And our concern there, which is why we wish to have this limited to not control and not higher than 20% interest in terms of the exception, is that they have complex structures, mixtures of companies, trusts, limited partnerships, and also parties that can hold through management agreements ability to control and materially influence what is happening. And so we think that there needs to be extra visibility. Many of the transactions, when assessed, will not be problematic, but we should see them in order to because they are investing in critical sectors that directly affect household services and goods, critical sectors for the Australian economy, the private equity firms.
Thank you. I have many more questions, but I had better share the call. So I'll go to you, Senator Smith. You're on mute.
Thank you, Chair, and thank you, officials, for making yourself available. To the ACCC, what quantum of additional resourcing has been provided to the ACCC to give effect to this new regime?
We have received $3.5 million to be prepared prior to 30 June next year, Senator. Then looking at 25-26 through to 27-28, we have received a $57 million increment from our current $16.5 million, and that is roughly funding for an additional 81 staff on top of our current 65.
Thank you very much. And that is in line with your request of government?
Yes, it is.
Your resourcing request of government?
It is, Senator.
Thank you very much. How quickly do you expect the new regime to reach a level of operational maturity?
We consider
both from the internal ACCC perspective, but also sort of economy-wide perspective.
We embraced the BCA suggestion to have the soft or voluntary start from 1 July next year, when it will still only be mandatory in 1 January. We think that is very beneficial for a smooth transition, but also for an important period of testing and refining our processes. So in the Statement of Goals implementation, we have set out that in the first quarter next year, we will issue guidance on each of the key areas, form, process and substantive analysis, that we will, after months of consultation, we will finalise that before 1 July, but we may very well then by December amend it again, looking at our experience, because practitioners are telling us they do expect to file some mergers, which they think will benefit from the mandated timelines, because even when it starts voluntarily, we will be bound by the timelines. So they think they will benefit from the timelines and also from early consideration, and not to have a transaction that might otherwise cross from December into January. So that first 6 months will be a very valuable period. Then from January 2026, when we have that it's mandatory, we will be building a body of precedent, which will then be able to be reviewed on thresholds 1 year, across the whole at 3 years. I'm comfortable that with the funding, with the experience we have currently with the rapid reviews in terms of the least difficult, but also transactions, or least risky, most importantly, but also because this reformed regime has the same test, the substantial lessening of competition test. It does not have the reversal of onus. So it does have an advantage in consistency that practitioners know it, the ACCC knows it, and we're not having to change that core element of what we're doing, which is a good benefit in terms of maturity, and also that the net public benefit test is a continuation of the current formal merger authorisation test in terms of net. So the two critical elements of the test remain the same. We are also significantly benefited by the expert advice that has been given by a former very senior member of the UK authority, which was very practical, which Treasury and I basically obtained and briefed, and it was very helpful. I do think Dr. Schott's comment that by December 2026 we will have built very substantial experience. If you are asking a question, real maturity, it's interesting, our expert advisor, said it took the CMA 7 to 8 years. Now, that is at an earlier time. We are benefiting from the consistency of the test and also from a lot of engagement with our global colleagues. I think we will do that more quickly, but the review at 3 years, I think, is a good time. I think there will have been the right time for the ACCC and the business community, with all the benefit of, frankly, continual transparency that the register and the process will give, as well as our reporting. I think at 3 years we will be able to make a meaningful assessment of a mature regime against the benefits that the government, I think the Parliament and the business community want to see from this reform.
Thank you. Dr. Schott also made the observation that in the implementation, it would require perhaps a reorientation of some of the skill set within the ACCC. You might have heard her comments. Could you just reflect on that? She made the observation that it would require, my word, not her, but an upskilling of some of the economic competency of the ACCC. Just want to make an observation on that point.
Thank you. We agree, and I think Rod Sims said the same. We do currently significantly draw upon our internal economics team, particularly in complicated matters. But we recognise that to deliver at scale a rapid assessment of an increased number, and we want to see an increased number, that is very clear, of an increased number of acquisitions, to triage them appropriately and, as we expect to do, decide 80% of them, at least in the first 15 to 20 business days. We will be relying upon sound and robust economic analysis to triage that and then approve them with great certainty, and then to proceed in the short and required statutory timeframes. We are currently, I respectfully say this in front of the Senate, because we're not trying to jump the gun, we just want to be ready. We are currently recruiting for more economists because we can see how important this is, and we want to ensure we have an enhanced team ready so that they will participate in the preparation of the draft guidance. Already our economics team is. But we definitely embrace that we need to increase our capacity there.
Two final questions, Chair, but if time allows, perhaps you could come back to me. Chair, you reflected on the submission from the BCA, and if I understand your earlier evidence, you're going to accommodate their particular remarks around the annual reporting on the performance of the merger review system and their commentary in that particular section of their submission.
Correct.
But perhaps to yourself and to the Treasury, they also make a recommendation in the removal of one section of the bill that refers to the level of concentration in a market. Do you or Treasury officials have a view on the BCA's submission in the context of that particular remark?
So the ACCC...
It's at the base of...
Yes, no, so go ahead.
Sorry, Chair.
It is a design question, and I will pass to the Treasury team, Senator. I will just note that the ACCC had agreed and said publicly that we agreed with concerns that a market share threshold introduces complexity and uncertainty for business.
Do Treasury officials have a comment on the BCA proposed amendment?
I might briefly say, Senator, that we think that the way the provision works, it operates to give power to the minister to make a determination. So there are a number of factors that need to be taken into account and that can be utilised in making that determination, and it's just one of those factors. I think we would advise that to maintain maximum flexibility, it is useful to continue to have that factor in the legislation, although the Treasurer's clearly decided that market concentration should not go into the notification thresholds as a way of assessing whether a matter should be notified. There may be circumstances in the future where a future Treasurer may want to come to a different view, and the provision as currently drafted would enable that. But I think the Treasurer has been very clear that is not going to be the notification threshold decision he makes. But I might see if my colleagues want to add anything to that.
I'll just intervene with some chairing and just say, Senator Smith, we'll go to 12:10 to allow Senator McKim to answer his questions, and I hope that's okay with witnesses. Ms Cascott-Leave, is that okay with you?
It is, thank you, Senator.
Thank you. Yes, Senator Smith, your question.
I think a Treasury official might have was going to add to the last remarks.
No, I don't think there was anything additional. Thank you.
Thank you very much. And then my final question then, has the Treasury calculated the economic benefit of the new regime?
Senator, I might have answer that one. The impact analysis that's been released has our best estimates of the potential gains. I think using UK and US sort of methodology, we came up with a number of somewhere around $300 to $700 million a year, although I would direct you to the analysis for the actual figures. And that doesn't include some of the benefits of the existing scheme, and it is based on overseas experience. In general, though, that there is some analysis from the Treasury and the RBA suggesting that the level of market competition has been falling, and the potential gains to the economy are 1 to 3 percentage points of GDP. And now we don't know the contribution of merger reform to that, but
over what period?
If you took it back, if you took the level of competition back to what it was in the early 2000s, and that's based on the rising profit shares. We don't know the contribution of merger reform to those potential gains, but it is potentially reasonably significant because merger reform is a long-term reform. While there might be only a small number of mergers that are affected every year, over time, that leads to a very significant improvement in competition over time.
Thank you. Thanks, Senator Smith. Senator McKim.
Well, thanks, Chair, and thanks, folks, for your assistance for the committee today. And Ms Cascott-Leigh, thanks for addressing some issues around the control exemption in your previous remarks. I guess acknowledging that there is provision in the legislation for the minister to determine by legislative instrument a class of acquisitions which are required to be notified and will not be able to rely on the controlled exemption. Noting that provision, is it the ACCC's view that that provision ameliorates all concerns that the ACCC has around the controlled exemption, or would you prefer that the controlled exemption simply wasn't in the legislation?
We think that the power does ameliorate it, and we are assured from the Treasurer's statements, including in the House, that he is going to limit that exemption in the case of unlisted private companies, and we have certainly been having discussions with the task force relating to other areas of changes of control that there will be a power to address in that manner through that power in the legislation.
Will there be any mergers that will not be required to be notified? I guess I'm after, so we've either got a provision where the control exemption doesn't exist, which I do note was the situation in the original draft legislation, and now we've got a regime where there is a control exemption which exists, but the minister's able to I guess, mitigate that by issuing a legislative instrument. Are there any potential mergers that are going to that would have had to have been notified if the control exemption didn't exist, which now may not have to be required to be notified under the new regime? I mean, will anything fall through the cracks?
I hear you, Senator. First, as I recall, but I will get the design team and the Treasury Task Force to confirm that, I think there was a provision in relation to share acquisitions for companies that reference control in the first legislation, and this provision was moving to more contain it, though the ACCC wants this power which the Treasurer has announced, to contain it even further. But I'll pass it to my colleague shortly. I just also want to give you assurance that in addition to that targeting in terms of control, the targeting sectors will apply regardless of these aspects. And in addition, we always retain the Section 50 prohibition of any acquisition that is substantially lessening of competition. That will be an enforcement role, but part of what we will use our additional funds to do is to monitor sectors, to pick up where we need to investigate and enforce for non-notified, whether they are above the threshold or below the threshold transactions.
Perhaps, Senator, I might just clarify that in the Exposure Draft Bill, Section 51 ABC 1 and 2 contained the control exemption. It was in a slightly different form. It also included a rebuttable presumption around the 20% voting power threshold. So in response to stakeholder feedback, we have clarified that it is a definition of control, and then we're looking to use the ministerial instrument to have a more targeted, specific threshold around the 20%. But it was included in the draft, and it's also included in the materials that accompanied the Treasurer's announcement on the 10th of April earlier this year.
All right, thanks. I appreciate that clarification. Ms. Cass-Gottlieb, you mentioned in one of your earlier responses that, and please correct me if I've got this wrong, that you'd provided the Treasurer with some advice around additional notification requirements in the supermarkets sector. Are you able to go into any more detail about that?
We have provided advice, and there is presently a process underway together with Treasury and their design team, legal design team in the task force, in terms of the drafting of an instrument that would be available if and upon, I'll express confidence in this, even upon passage of the legislation, that would then be present for Parliament's consideration as a disallowable instrument, that it would look at the supermarket sector, which, because we have seen firstly that there is significant concentration there, with 67% being held by the two largest, of course Woolworths and Coles, that we are also concerned that in this concentrated sector, transactions at local area level, multiple of them, reduce competition at a local area level, but also have the effect in a chain sense of increasing the economies of scale of larger players and making it more difficult for smaller players, not only in their small local sectors. We have also observed over the last 10 to 15 years, a notable decline in the share of sales for independent supermarkets operating in Australia. So Metcash, as the supplier to and proxy for independent stores, has had a decrease of more than 10%. So we have set out in a letter to the Treasurer the evidence before us that we can put before the Treasurer in support of that.
All right, thank you, and thank you. That's very helpful. And so, just to be clear, has it been your advice in that letter to the Treasurer that such a disallowable instrument should be provided to the Parliament?
Yes, it has been our advice to use this power if the bill is passed.
Yeah, okay. Yes, thank you, Ms. Cascott. Can I ask the Treasury folks, please, firstly, in relation to that, has there been any advice? So just when I say that, I just mean the last matter that I was discussing with Ms. Cascott. Has there been any advice that you've prepared for the Treasurer in regards to that?
There was initial advice given that an instrument could be prepared, but there hasn't been detailed advice on what the instrument might look like. That's something that Treasury are working on as part of the process of considering what an instrument might look like. We've gathered the evidence from the ACCC, and it's very much a work in progress. Obviously, it depends on the passage of the bill before the power can be used.
No, I do understand that last point. Would it be an accurate characterisation to suggest that Treasury is currently drafting such an instrument, or are you just going through the preliminary work prior to that step?
We have a drafting team that Ms Robinson is responsible for, and she can explain what's going on.
Thank you. Senator, we do have an in-house drafting capacity, fortunately, in Treasury to prepare us well for implementation. Assuming the bill passes, we are well prepared at this point to have a draft instrument ready for the Treasurer to consider in consultation with the ACCC, and we would expect consultation processes to be undertaken on those instruments.
All right, thank you. And just slightly separately, but also for Treasury folks, what are the timelines in regards to the legislative instrument relating to mandatory notification thresholds?
That's also a piece of work that's been given a great deal of priority. Ms Robinson might be best placed to give more detail.
Absolutely. So we're looking at the threshold notification requirements in terms of both of those instruments together because they obviously work in tandem. We're in the process for both of developing drafting instructions. So again, I think we're well placed should the bill pass to have those instruments ready and out for consultation.
Look, I'll just make the obvious point that there's not many city weeks left this year. Obviously, we're all operating without full knowledge of if so, when the legislation will pass. But perhaps I could ask it this way: how long post the passage of the legislation would you expect before the Parliament saw that particular instrument relating to the notification thresholds?
So in that regard, it's really a matter for government and the Treasurer, obviously, in terms of the specific timing of when instruments would be made and consulted on. It's up to the Treasurer and government, again, to decide on whether there's early consultation on drafts even ahead of the bill passing. There's flexibility. Obviously, it can't be made, but there's nothing to stop sort of early consultation around the substance of what those instruments might contain. So we're a bit guided in terms of passage, the Parliament, but also then the Treasurer and the government in terms of next steps for prioritisation.
I think I'll just conclude there. We're really at time, but I'll just offer Ms. Cass-Gottlieb just a final opportunity to comment on this question of timeliness. How important is it to the work of the ACCC that this bill, which has been extremely well consulted over an extensive period of time, how important is it to your work that the bill has timely passage through the Parliament?
We are well primed and in fact have already done the plan and are working. We are only able responsibly to dedicate the resources that will mean we will be ready to consult in the first quarter of next year and be ready to take the first applications in June if by the end of this year we know the legislation has passed. We have a very significant work program to do. We have $3.5 million from the government to be able to assist to do it by 30 June. But I can't, in proper administration of resources, dedicate the number of people full-time to be ready, taking them away from the other current responsibilities and roles that we have that I need to put there. To be ready for 30 June, I need to know before the end of this year.
Okay, thank you very much. And thank you, Ms. Cass-Gottlieb, for your evidence. And thank you to your team as well. Thank you also to the Treasury officials for appearing today. That concludes our hearing today. Thank you to all the witnesses who appeared earlier as well, and to Hansard, to Broadcasting, to Secretariat for their assistance. Questions on notice, answers to them are due Thursday the 7th of November, and the committee now stands adjourned. Thank you all very much.